good evening, and welcome to Maine Law's Black History Month presentation. We're honored tonight to bring you Minnesota Attorney General Keith Ellison. I begin this evening by thanking AG Ellison for being here tonight. He is actually in Maine, and he has taken the time to meet with members of the law school community and others who were really pleased to welcome him to Maine. It's truly an indication of his Michigan and Minnesotan roots that nothing about the storm that has caused us to pivot to this webinar format caused him to pause in his trip to Maine. We're pleased and grateful to have him here, particularly given how very busy he and his office have been this week. I also want to thank the people that have helped us stand up this webinar on very short notice. We hoped for days that the storm would blow out to sea, but it was tenacious, and here we are through the miracles of modern technology. However, it's not entirely miracles, and there may be a few glitches as the evening proceeds, so please forgive us and have some patience. And I have to say that it has always been my experience that the busiest people step up in an emergency. Nicole Vinyl, who is Maine Law's amazing COO, has just been wonderful, helping us field all of the necessary challenges as we pivoted to a webinar. Nancy Mackin, my wonderful assistant, Carrie Wilshusen, Maine Law's Dean of Student Affairs, and Emma Ambrose, our new Media and Communications Director, and including Vice Dean Dimitri Baum, and behind the scenes, Jennifer Crane, Rob Pareca, and Cameron McMillan, who stepped in at the last minute. I am so grateful for your help. And we are all very grateful and proud of our Maine Law students, 3 of whom have stepped up to organize the question and answer segment of this evening's program. When Attorney General Ellison has concluded his formal remarks, 3 Maine Law students, Ambrose Dawson, who is a 2L, Aisha Simon, also a 2L, and Sarah Hassan, who is in the midst of a demanding 1L year, will organize the questions that have come in and present them to the Attorney General. And I am delighted to welcome to the audience tonight many of those individuals who are working within Maine to effectuate criminal justice reforms that bring real meaning to the phrase justice for all. Included in the audience tonight are several members of Maine's legislature and many members of the Maine criminal justice litigation community, including Maine's own Attorney General, Aaron Fry, Maine's newest U.S. Attorney, Darcy McElwee, the Executive Director of the Maine Association of Criminal Defense Lawyers, Tina Netto, and so many more. An additional thanks go out, as always, to the University of Maine System's Chancellor, Dan Malloy, for his constant support for the rule of law and the advocates who champion justice in so many ways. And of course, to my good friend, a Maine Law graduate, Maine's former Attorney General, and now a law professor at a different law school, Jim Tierney. And of course, thanks to all of you for joining us digitally on a snowy Friday night at the end of school vacation week. We're so glad you could be here. So let's get going. Minnesota's Attorney General is elected by the public, in contrast to Maine's Attorney General, who's selected by the Maine legislature. Attorney General Ellison successfully ran for that office in 2018 and took office on January 7th, 2019. He has served 1 term and has announced that he will stand for election again this fall. Here's a brief overview of how he got here. Keith Ellison was born and raised in Detroit, Michigan. He converted from Catholicism to Islam at the age of 19. He graduated from Wayne State College in 1986, receiving his bachelor's degree in economics. He received his JD from the University of Minnesota in Minneapolis. In his first years out of law school, he spent time in private practice and quite a bit of time in nonprofit practice as a legal service provider and director. After over a decade of practice, Attorney Ellison ran for and was elected to the Minnesota House of Representatives. And then in 2007, he was elected to the United States House of Representatives. He ran for and won that seat in Congress again in 5 more elections. When he was elected to Congress in 2007, Congressman Ellison was the first African-American from Minnesota elected to Congress and the first Muslim elected to Congress from any state. His work in Congress was prolific. The National House of Representatives History site reports that A.G. Ellison introduced more than 200 bills and resolutions during his 12 years in the House. Much of his attention and his successes were focused on consumer protection matters, including predatory lending and credit practices and discriminatory foreclosure practices. In 2018, he shifted course and ran successfully for the office of Minnesota Attorney General. Just over a year into his term as Attorney General, on May 25th, 2020, in Minneapolis, George Floyd was stopped by the Minneapolis police, suspected of having used a counterfeit $20 bill. The New York Times reported that 17 minutes after the first squad car arrived, George Floyd was unconscious, pinned under 3 police officers. One of those officers, Derek Chauvin, knelt on Mr. Floyd's neck for somewhere between 7 and 9 minutes. Mr. Floyd never regained consciousness, and he died on the ground under Officer Chauvin's knee as the public and soon the whole world watched. Attorney General Keith Ellison led the successful prosecution of Officer Chauvin, who was found guilty by a jury of unintentional second-degree murder, third-degree murder, and second-degree manslaughter. He's now serving a sentence of 22.5 years. Yesterday, a jury determined that the 3 other officers who were involved did, in fact, violate George Floyd's civil rights. Attorney General Ellison has written and spoken extensively on the topic of police and criminal justice reform and the cycle of inaction that has followed years of calls for reform. So I will not take up any more of the time you have with him. Attorney General Ellison, the floor is yours.
Thank you, Dean. Let me thank you and thank you again for this wonderful invitation. I wish we could all be in the hall there at the law school together. There's something special about that. We were able to be together earlier today, and it was awesome. You know, being on Zoom, as you said, there's the magic of technology which brings us together despite the snowstorm that's going on strong outside. And I want to thank you. I want to thank you for your years of service. Thank you for your service to the Maine Supreme Court, and thank you for your service to Maine Law School. You know, Maine Law is a wonderful institution producing people who are dedicated to the rule of law, liberty, and justice for all. So bless you and thank you, and I hope you're staying warm. And it looks like you're doing that. And also let me thank my friend Aaron Fry. Aaron is Attorney General in Maine right now. He and our colleagues, we have occasion to talk and confer, and it's always good to be with you, Aaron. I don't know if you're able to shout out yourself, but I just want you to know that I know you're out there and we're grateful for you. And I have to also shout out my good friend, Jim Turney, former Attorney General in Maine. Let me tell you, when I first started learning this business of being an Attorney General a few years ago, at our orientation, the one person who stood out more than others was Jim Turney, who has really made the state attorney general the subject of scholarship and study. He teaches courses on it at other law schools, and he even got me to start a course in it at University of Minnesota Law School. And I want to assure everyone that it has been a tremendous learning experience to teach that course. Jim, thank you for always being there when I call you. Thanks for being ready for advice, for admonitions, and for even a little encouragement. You're the best. I appreciate you. And again, let me say thank you to all of the leaders and students and dignitaries I had the chance to meet earlier today in person. We had some very special meetings. I'll never forget you, and I hope to stay in touch. And so, Mama George Floyd, 46 years old, cried out. He cried that out in the waning moments of his life. Mama, I'm through. He gasped that as Derek Floyd ground his knee into George Floyd's neck and his face into the asphalt of the road surface. I can't breathe, Floyd declared at least 15 times during the first 4 minutes of 17-year-old Darnella Frazier's smartphone video. And then his voice began to fade. His pleas grew further apart, and he eventually went silent. Then his voice stopped, and he was silent and completely unresponsive. Bystanders of all ages, colors, and cultures stood by, shocked, appalled, and armed with smartphones, and they all pleaded at least 17 times with officers to check Floyd's pulse, to get off of him, to give him aid. And of course, George Floyd wouldn't survive. And the world knows this all to be true because you saw it painfully over the course of not just Darnella Frazier's video, but many other videos as well. Worldwide, people all over the United States and all over the world got out into the streets, protested, and demanded action. And in the tumult of that, the governor called me and said, look, I know that your primary jurisdiction is not local prosecutions, but we need you to help out. I couldn't say no. I said, okay. And then I figured out how we were going to do it. And then we began to put together a prosecution team that brought about a result of a conviction of George Floyd's killer just last March. But the fact is that about 1,000 people a year die in officer-involved incidents. That number has held constant for many years. And George Floyd is one of those persons. George Floyd's death at the hands of Minneapolis police officers was not typical, but in many ways, sadly, it was not to be unexpected. I'd like to share a few slides with you to talk about what concerns me as a cycle of inaction that we have been seeing for many, many years, and that we have the power to bring to a close. And so let me begin the slide. Hope I'm doing this right. Now, the title of this presentation is The Death of George Floyd and the Breaking of the Cycle of Inaction. I'd like you to focus on this word inaction. It really is what we're about to discuss today. But first, a few quotes just to set the table properly. Let's take a look at quotes by Herman Melville. The truth, uncompromisingly told, will always have its jagged edges. My friends, if you want to reform policing, if you want to reduce deadly force encounters between citizens and police, there's going to have to be some frank dialogue, and it will not always be comfortable. Some of these conversations will have jagged edges, but if we can face it, we can fix it. We just have to be ready to face some moments of being uncomfortable. Also, when the law ends, tyranny begins. Make no mistake about it, excessive force, sometimes referred to as police brutality, is lawless. The Constitution of the United States, the Fourth Amendment, says that citizens have the right to be free of unreasonable search and seizure. When an officer uses excessive force that is unreasonable seizure of a person, it's unconstitutional, and we all must stand and say that it is lawless conduct. And where law ends, tyranny begins. Arbitrary violence by the state is not recognized as within the law or consistent with international norms or national norms of human rights. And then another quote, just to set the table, by an American great leader, John F. Kennedy, who said, "Those who make peaceful revolution impossible will make violent revolution inevitable." Kennedy was not making a call for anything. He was not endorsing anything. He was simply observing what we all know to be true. If you have a consistent and chronic application of unconstitutional policing from time to time, people will take to the streets and respond in an unhealthy, unhelpful way. If we want to avoid these things, we have to take action and engage in positive reforms, which will make our society more peaceful and will also allow voices of the denied to be heard. Let's talk about where we are now. Let's talk about the society as it exists at this point. Talk about really the harms associated with not addressing police misconduct. Let's start with police settlements. Public records from 31 of 50 cities with the highest police to civilian ratios in our country show that about $3 billion has been spent to settle misconduct over the last 10 years. New York City, for example, in 2019 paid out $175 million in civil judgments, Chicago, $85 million, Minneapolis, about $70 million. And let me tell you, 2 cases alone hit us for $46 million. The case of Justine Rushtek, a white woman who was shot and killed by a Minneapolis police officer. And that officer was prosecuted for a 3rd-degree murder. That case was struck by the Minnesota Supreme Court. His 2nd-degree manslaughter conviction does stand, but the payout was $20 million. And in the George Floyd case, $26 million. Now, I don't begrudge the families for seeking those settlements at all, but what I will say is if we simply address the issue of police misconduct, we could not pay out those massive settlements and devote those precious resources into other things, including hiring more police officers, getting more lighting, housing issues, transportation. There's no shortage of needs, but we're expending it on essentially addressing and paying for police misconduct. The second item is not settlement of civil rights cases, but the cost of civil unrest. Civil unrest, sooner or later, will occur if you do not address chronic excessive force by police. In the last, in the civil unrest associated with the George Floyd murder, $50 million in damages hit the Twin Cities. You can see the picture right there. That's Lake Street in Minneapolis. That's what it looked like shortly after tragedy struck. Across 20 states, could cost insurance companies $1 billion to $2 billion, possibly making this one of the most expensive cases of civil unrest in American history, sparked by none other than the action that George Floyd suffered at the hands of Minneapolis police officers. And let's just look down the whole list. May 26th to June 8th, you see 20 states across America, 1 to 2 billion. Los Angeles in 1992, that's Rodney King. In today's dollars, 1.42 billion. Los Angeles in 65, the Watts riots, 357 million. Detroit in 67, 322 million. Miami, 204 million. Look at the chart for yourself, all the way down to Chicago, 97 million in 68, and the list goes on. According to scholars that have studied this, this is an extensive, serious problem. I would refer you to a book written by Elizabeth Hinton of Yale. She wrote America on Fire, The Untold History of Police Violence and Black Rebellion Since the 60s. According to America on Fire, Elizabeth Hinton, between 1964 and 2001, there were nearly 2,000 urban rebellions in the United States that were sparked by racially biased policing, and all of them had a dollar figure associated. Just deadly force nationally, about 1,000 people a year are killed, as I already mentioned. In 2020, 18 days where police were not involved in an officer-involved incident. And from 2013 to 2020, officers were not charged with any crime in 98.3% of officer-involved deaths. Now, I want to be clear, there are cases where police officers must use lethal force. I declined charging cases with involving officers more than I've charged them, but the fact is 98.3 raises questions. It seems, given the large number of incidents that occur, it's something that number may be not reflective of the scale of the problem. And in this number are people like Eric Garner, people like, well, many others as well, who all of which come to mind. Oh, Tamir Rice, others like that, and even Breonna Taylor. One officer was charged, but many others involved were not. And of course, I don't want to neglect the fact that many officers' lives are at risk as well. 46 officers were murdered in the line of duty in 2020. In the first 6 months of 2021, 37 officers have been murdered in the line of duty. What we want to do is reduce deadly force encounters with police, involving police, and that includes the lives of officers, which we equally and absolutely want to protect as well. And the recent study goes out that the scale of the problem might be underestimated. A 2021 study on fatal police violence shows that more than half of the killings by police were left unreported. And of course, as we all know, the Innocence Project has won the exoneration of many people who were actually innocent of crimes that they were convicted of and did time for. And according to government misconduct and convicting the innocent, a study based on 2,400 exonerations, many involved what all of us would describe as misconduct by investigative law enforcement. But one thing is incalculable, and that is trust, the broken bond between the citizens and the police who protect them. This is an essential bond which we cannot allow to be broken, but it is frayed. We have to agree. And people depend on police. Police their actions protect citizens every day. And a tight bond between police and citizens makes for a safer community. We know this. We know that when citizens will respond to subpoenas, will give statements, will share information, the communities are safer. When the bond of trust is broken, we know that they are more at risk. And so this is a loss very hard to put a number on, but we all know exists. So what we're talking about, damage to city finances and trust equals social disintegration and exploding divisions. Not only is the frayed relationship between law enforcement and some communities damaging in terms of city budgets, in terms of trust and other things, it also is damaging to national security. In the aftermath of the George Floyd uprisings, we know that groups of social media trolls from Vladimir Putin's Russia were sending messages to the United States via social media that were exacerbating the tensions in our communities, making things worse. Here's a quote from Fiona Hill from Foreign Affairs. "The fire was already burning. All Putin had to do was pour on some gasoline. The polarization of American society has become a national security threat, acting as a barrier to the collective action necessary for combating catastrophes and thwarting external dangers." The point is, if we don't address this problem, we are putting our nation at risk because a safe national security policy requires us to have a level of trust and unity, which the existing status quo leaves us vulnerable to. Which brings me back to the beginning. This problem that I've been describing is not a new problem. It's not a problem localized in one community. In fact, Kenneth Clark, and law students will appreciate who he is. He is the sociologist who provided Thurgood Marshall with the basis of evidence, proof of damages to Black school kids in the Brown versus Board of Education case. In that case, he and his wife did the doll study, which showed systematically that segregation harmed the psyche and the confidence of Black school children, when he showed really a large number of children, a large sample size of Black children who were in segregated schools, a series of white and Black dolls, and asked them questions like, which doll is nicer? Which doll is smarter? And the Black children systematically chose the white doll, thereby showing that segregation damaged the confidence and self-esteem of Black school kids. Many years later, after 1954, in fact, in 1967, he was called upon again, and he spoke at the Kerner Commission, which did a report on the civil unrest of the 1960s. And in his testimony, he said, I read that report, the 1919 Chicago riot. It was as if we were reading the report of the investigating committee in the Harlem riot of 1935, the report of the investigative committee of the Harlem riot of 1943, the report on the McCone Commission of the Watts riots. I must again in candor say to you, members of this commission, it is a kind of Alice in Wonderland with the same moving picture reshown over and over again, and the same analysis, the same recommendation, and the same inaction. You know, when I became Attorney General, before George Floyd was ever injured or met up with Derek Chauvin, I gathered together law enforcement officials, civil rights leaders, and others to talk about how we can reduce deadly force encounters for citizens and police. And the man you see sitting to my left is a fellow named John Harrington. I just got off the phone with him around 20 minutes ago. And John Harrington, his father was a police officer, his uncles are police officers. He himself was a police officer. He was the police chief in St. Paul. He was the chief of the Metropolitan Transit System in Minnesota. And now he is the commissioner of public safety. This guy bleeds blue. He and I teamed up to have a series of conversations to try to reduce deadly force encounters with police. The working group Reducing Deadly Force Encounters with Police met in August, which is more than 6-8 months before George Floyd met with Derek Chauvin. And by February 24th, a few months before that fatal incident on Memorial Day 2020, we released a series of 28 recommendations and 33 action steps. We didn't wait for a crisis. We tried to do something. Since then, the George Floyd Justice and Policing Act, which was in Congress, has died in Congress, and it appears as though no action will be taken on that piece of national legislation, which I believe could help prevent all of the bad things that I just got through highlighting for you, including civil rights payouts, civil loss of trust, loss of life, and many other things that I identified already. But let me tell you, this is not a situation that is hopeless. We can reduce deadly force encounters with police. In fact, Newark already has done it. Newark, New Jersey officers fired 0 shots in 2020. And it's because they embraced the problem and they did something about it. And in Camden, New Jersey, the same thing. These cities are reducing deadly force encounters with police, reducing payouts, saving lives, building trust, and actually being more effective at law enforcement. Camden and Newark got record numbers of guns off the street, and they, in a time when they were looking at worse, when the whole country was looking at spiking crime rates, they've been able to try to keep it level and been more effective than other places that have not. So actually, effective addressing of police misconduct leads to greater public safety, greater officer morale. The bottom line is, folks, no one's above the law and no one can be beneath it. An officer cannot be above the law, and a citizen like George Floyd cannot be beneath it. We need to have equal justice under the law. That is what us lawyers are sworn to uphold. And lawyers, I believe, are in a critical and unique role to help advance this cause. Let me show you two pictures just to give you some orientation. The picture on the right is from 1920 Duluth, Minnesota. You will see the three men, two hanging from the light pole, one on the ground, and other men who just got out of an orchestra concert, all there, some of them smiling, struggling to get to the photo. On the other side, you have another group of citizens, a multiracial group of citizens, a group of citizens armed with cell phones who are calling for justice, calling for George Floyd's life to be spared. The fact is that there are many lessons from the Chauvin trial, but the most important one of them is that citizens can make a difference. If you add up the case from yesterday, the verdicts from yesterday, with the verdict in the Kim Potter case, together with the Derek Chauvin verdict, I think you see a few things. One is that the excuse of I'm a rookie isn't going to work anymore. That's what yesterday tells us. The Nuremberg defense, the defense that I was just following orders, will not work into the future. Officers who've been trained over 18 months will not be able to escape responsibility by blaming someone else. Juries are telling us, and this is a lesson from the Chauvin trial, that while Congress might not act, 12 randomly selected citizens who are fully briefed on all the facts and hear all the testimony will convict. I'm not sure that that was true 20 years ago. It certainly wasn't true when Rodney King in 1991 was savagely beaten, struck 58 times, also on video, but the officers who did it, Stacy Kuhn, Timothy Wynn, Lawrence Powell, and Officer Bricinio, escaped accountability when their case was moved to Simi Valley and the jury acquitted them. Today, juries are convicting, and I think it's important to understand that the change in sensibility of the jury, the citizens of today are simply much less patient. Maybe it's because they've seen examples which years ago they just didn't see because we didn't have the video technology. But this is an important lesson from the Chauvin trial. The murder of George Floyd was typical, and in some ways it wasn't. It was typical in that this problem has been going on for 100 years. And it was not because you had citizens who stood up, came and testified, who whipped out video and took that video and shared it with law enforcement investigation in these cases. And there are cases in which prosecutors are willing to take these cases these days because we know that justice is required and accountability is the first step toward justice. These citizens, they didn't stop. They stepped up. It was important for them to do so, and they did. Their video and their witness exposed very hidden realities. We know, and I want to just make it clear that the first reporting from Minneapolis Police Department about George Floyd's murder is that he was killed because of a medical emergency. They made it sound like a stroke or a heart attack. They didn't mention use of force at all, but that hidden reality was exposed by the video. I think it's also important to note that the United States enjoys and has enjoyed a reputation as a beacon for civil and human rights around the world. I would caution everybody to remember that nearly every country on the globe has had a history of slavery and displacement and unfairness, and there's no country that really can say that they don't have that in their history. Our country has had that history. My argument is that we should stay where we are and make our country as just as we can, understanding that by comparison, every country has struggled and has its historic challenges. But let me tell you, as other countries look to the United States and say, hey, they have addressed serious problems of inequity in their own country, those same countries are looking at us now and they're wondering, what are we going to do? And I want to tell you that whether it's Buenos Aires or Brisbane or Cardiff, Wales, or Cape Town or Dakar or Dublin, all over the world, you see people calling for justice and recognizing the story of George Floyd. Justicia para George Floyd, justice for George Floyd. And here's the conviction of Derek Chauvin being let off. It did not bring me any joy to see this that day. I was in the courtroom because it didn't bring me any joy, because even though we were trying to prosecute him and convict him, what actually happened is that a jury of his peers found him guilty beyond a reasonable doubt of murdering George Floyd. But it was his duty to protect and serve George Floyd. That's sad. That's not a good moment. That's a sad moment in our history, but it's a necessary moment, a moment that I believe our country needs in order to have equal justice under the law. And so as the crowd assembled to call for George Floyd's life was multicultural in nature, so was our team. We have right here African-Americans, Latinos, whites, and Asian people, all on this prosecution team designed to bring about a higher quality of justice and a higher quality of accountability for George Floyd. So I would submit to you again, and I'll repeat, excessive force is a violation of the Fourth Amendment prohibition against unreasonable search and seizure. It is a unconstitutional, unreasonable seizure of a person. And that is what the three officers were convicted of yesterday, violating his civil and human rights. It is important to understand that none of us would doubt that a violation of voting rights would be a violation of somebody's civil rights. But excessive force is also a violation of civil rights, and no free society can stand by where agents of the state are allowed to arbitrarily exert excessive and unreasonable force on citizens. This is not some sort of radical thing. It is the heart of our Constitution. And so I believe that simply prosecuting criminal and unconstitutional conduct will not get it done. We've got to do more, and we've got to make it less likely that tragic incidents will happen by making investments in housing, addressing wealth disparities, correcting educational disparities, and more. And I've been asked maybe 1,000 times since this case, can we break the cycle of inaction? My answer is very simple. Yes, if we act. We have to act. We have to act. If the Congress will not act, we have to act locally. Jurors are clearly willing to act. And I think the rest of us in the society have to act as well. And I just want to leave you with this thought. You might think after this presentation that this is a hopeless, intractable problem, that we're simply stuck with this. I showed you examples in Newark, New Jersey, and Camden, New Jersey, and Ithaca, New York, where real change is being made. But let me just point to you some examples from history where tragic incidents were followed by steps forward in the cause of justice and human rights. Let me give the example of Jimmy Lee Jackson. Jimmy Lee Jackson was a civil rights activist in Marion, Alabama, and he was on a night march in 1965 when an Alabama trooper chased him into a diner. He was unarmed, he was a marcher, and just shot him in cold blood and killed him. He was a soldier. He was a man who had done many good things in his life and was killed unjustly. That illegal shooting led to John Lewis and Hosea Williams going on a march, planning the march from Selma, Alabama to Montgomery, Alabama. And what happened next is they were beaten and trampled by horses at the command of Sheriff Clark at Edmund Pettus Bridge on March 7th, 1965. After that, in some legal maneuverings, Martin Luther King led the march from Selma to Montgomery and then gave a historic speech in front of the Alabama State Legislature. And at that time, only a few months later, Lyndon Baines Johnson, President of the United States, signed the Voting Rights Act. Also, Sergeant Isaac Woodard, a decorated soldier in the United States Army, served admirably and with distinction in World War II, released 3 hours later, was on a bus going home and had to go to the bathroom, got into a verbal argument with the driver. There were no fisticuffs exchanged. It was peaceful, but it was a verbal argument. The driver notified the police when they got to Batesburg, South Carolina, and the chief pulled him off, beat him, poured alcohol on him, and then took the small end of a baton nightstick and jammed it into his eye socket, blinding him. 6 months later, leaders of the NAACP were able to meet with President Truman, informed him about this tragic incident, and President Truman demanded that the Attorney General order the US Attorney to prosecute the sheriff who did this. He did, and yet the case was so poorly prosecuted, so incompetently prosecuted, that even though the sheriff admitted to blinding Isaac Woodard, he was acquitted. And the judge in the case was so appalled that that judge was radicalized and became a leader in the civil rights movement himself, heard many cases, wrote an opinion in a case called Elliott versus Griggs, and then was in the minority on an appellate panel. But his minority dissent ended up being the majority in a companion case that was put with his case, known as Brown versus Board of Education. That was Judge Julius Waddies Waring, and there's a documentary about it, and I urge all of you to watch it very carefully. President Truman went on to desegregate the military and order the first Civil Rights Commission under his presidency. And let me tell you, this was no small thing, because although Truman was a man of his times, he has recorded documentation using racial slur, but he was so offended by what happened to Isaac Woodard that he took the actions that I just described. And they led to the desegregation of schools in the United States. And one could say that Brown versus Board of Education was an inflection point in American history and really set off in earnest the civil rights movement. So these horrible, tragic events can lead to serious advancements. I'm hoping that George Floyd does too. We cannot bring George Floyd back. He's gone to us. He is a part of history. But that doesn't mean that we can't make more out of the moment than we have already. And I urge all of us to step forward and do what we can to make liberty and justice for all the law of the land and the culture of our society. Let me say this to you, lawyers and law students. The great Charles Hamilton Houston, the mentor of Thurgood Marshall, said that a lawyer is either a social engineer or a parasite on society. I believe University of Maine law students are social engineers. Your dean wants you to be a constructive member of the bar, an aid to the higher quality of justice in our communities, wants you to pursue your career wherever you find it. Maybe you want to be a corporate lawyer. Maybe you want to be a public interest lawyer. Maybe you want to be a plaintiff's civil rights lawyer or a plaintiff's business litigator. It doesn't matter. There's room for everybody in making the rule of law and justice prevail in America and in Maine. And we all hope and pray that you take up the mantle. So leaders are people who will choose an uncertain but possibly better future than a certain but terrible status quo. Leaders take chances. Leaders don't wait around and hope for the best. Leaders don't ask themselves, does this make me look good? Leaders don't ask themselves, is this expedient? They ask themselves, is it right to do? And they move forward even in uncertain moments. And this is an uncertain moment. We don't know what's going to happen, but we know the status quo is not working. And I think that we should step forward and do the best we can with the opportunities we've been given as law students and lawyers in Maine and around the country. So with that, I thank you for listening, and that'll conclude my comments.
Good evening, Attorney General Ellison, thank you very much for your riveting talk. And I have some questions that have been posed by some of our student body, staff, and members of the community. The first question is, to the extent that you can comment, looking back, would you have handled anything differently regarding the charging decisions and communications surrounding them for the officers involved in George Floyd's killing?
That's a great question. And I think it's always good to reflect. As I sit here today, I don't have any regrets. I don't know else what I would have done. I can tell you this. There were some people who said, well, you should charge first-degree murder. I'm glad that I didn't. I think we would have lost that charge. And I think as a prosecutor, it's unethical to charge more than what the evidence will provide. We didn't have any evidence of premeditation and deliberation. And so I'm glad we didn't charge that. So, you know, at this point, I have to say that it has not occurred to me that we should have made some different decisions, but I'm always open for recommendations.
Attorney General Ellison, thank you so much for your talk this evening. My name is Aisha Simon. So my question is from Attorney General Tierney. He wanted us to bring up something that you often touch on in your conversations and your discussions with people, the pressures on police officers, the PTSD that they suffer, the police suicides, and the resignations. So we were wondering if you could address that for a moment.
Yeah, let me tell you this. One of the damaging things about the status quo is that it appears that the way that we do policing and law enforcement is damaging to the people we ask to do it. Right now, in Minneapolis, we have a force of about 800. 200 have already filed for disability leave because of PTSD. And there's every reason to believe that these are authentic cases. They've been screened by doctors and medical professionals who have provided the documentation for them. But what if we took a different turn? I mean, the point is police officers suffer from suicide. The 4 officers who were at the January 6th Capitol riot, 4 of them have taken their own lives. And this is not an uncommon thing. Alcoholism, other things like that, very, very difficult for police officers, not to mention the resignations. And recruiting was tough even before George Floyd. And I can tell you that we need to look at how we do policing also for the benefit of police officers, most of whom go into policing so that they can help people, so that they can serve community. And yet over the course of time, they suffer injuries, not only to themselves physically, not only do they lose their lives on occasion, but also mental and emotional damage.
Thank you so much. Hi, I think we've met earlier, but just in case you forgot, I'm Sarah.
Of course. How you doing? I called you Sada, but maybe I should call you Sarah. Sorry about that.
It's okay. As you may or may not know, Maine does not have a public defender's office. Instead, Maine relies on a list of private attorneys that provide indigent legal services. So my question to you is, what do you make of this system from both the constitutional perspective and a policy perspective?
Well, before I would comment, I'd want to know how it's going. I mean, what do criminal defendants and what do the lawyers who provide the services and what do the judges say? Is it working out? I can tell you that in Minnesota, we have public defenders offices, and I used to run one of them. And I can tell, I can't compare, but I can say that when you gather people together who do the same kind of work, you build institutional memory, you build institutional resources like brief banks. And, you know, there are certain advantages to be had. But I don't really know because I've never experienced the system here in Maine, so I don't want to judge, but I will say that, that there are benefits to doing it in a PD's office.
Okay, General, the next question that I have is, so Minnesota has consistently been ranked among the worst states when it comes to the racial economic inequality. And the question is, are violent police encounters, police misconduct, and high crime rates an inevitable consequence of this inequality? And how can the problem be solved at the policing or prosecutorial level, or even at other levels of state or society?
Well, let me say, I do believe that the inequality contributes to the problem, but I'm reluctant to say that it's the sole cause of the problem, because if I were to say that, what I would be saying is that we were stuck in this inevitable situation where we couldn't make any progress on police community relations until we made progress on these other sociological and economic disparities. We can do better now on policing. We can do better now. And yes, absolutely, we need to do better on housing. I think that right now we could make some dramatic steps forward in housing as well. And I think those would reduce the negative encounters that people have with police. So often policing is employed as a unit of social control, not necessarily just to keep people safe. Like when the police clear out so like in Minnesota, I don't know if y'all have this in Maine, but in Minnesota, you can drive around and see 20 or 30 tents under an overpass or in a field somewhere where homeless people live. And if you ask your police officers to clear out those locations, then what you're literally doing is they're using the police department to police poverty. That's what you're doing. There's no other way to explain what you're doing. The answer is clearly to house these people, right? And so I think that, that yes, it would contribute to a better situation if we eliminated those homelessness and poverty and the disparities in home ownership, disparities in educational attainment. But at the same time, it's no excuse to not improve the situation between police and community right here, right now, today.
All right, General Ellison, I think I'm up. We're going to shift a little bit away from the policing, and my question is in the role as a prosecutor. What role for attorneys in general, what role should an attorney's personal sense of morality play in the decisions about when and how to pursue particular claims or charges, or not to pursue those?
Aisha, being a prosecutor is the one job you can do where your job is to do what's right. That's the one job. If you represent a client, to a certain extent, your job is to be a zealous advocate for that client. Not even to a certain extent. That's your job. The rules of professional responsibility say that's your job. And your limit is if they ask you to do something unethical or immoral or wrong. But the rules of the profession are zealous advocate, your client has a right to a zealous advocate, and there are privileges of confidentiality that help you, augment that zealous advocacy and other things. But as a prosecutor, you just got to do the right thing. The problem is, what's the right thing? Often moral choices are difficult to make, particularly if we don't reflect on them very much. But I would urge those of you out there who are considering what legal practice you want to have, to think about being a prosecutor, because that's the one job where if you believe somebody deserves a break, you can get them in a treatment program or something else rather than letting them rot away in a prison. As a prosecutor, and if somebody is particularly harmful and dangerous to community, you can ask for more time for the judge because they need to be incapacitated, and so my view is that your moral compass is very important in prosecuting. You should consult the sentencing guidelines. You should consult your colleagues. You should consult your own conscience. But I certainly believe that it has an important role to play.
Well, you've made the case for me. I have a small follow-up. I'm curious, you talked about reflecting on the decisions and consulting your own sense of morality. How do you do that?
Well, I think you should read a lot about morality. You should read a lot about justice. I would recommend that you read the writings of Hannah Arendt, who wrote about her experiences observing the Holocaust. You might want to read a book by Danielle Sered. Her book is entitled Until We Reckon. You might want to consult religious texts if that's, what you believe in, but you should ask yourself, you should never be satisfied with your own sense of what's justice. You should constantly bounce it off of other people. And you should remember, mercy is a part of justice. Second chances are a part of justice. But sometimes, some people, justice means that they should lose their freedom. I personally could never ask for the death penalty. I wouldn't ask for the death penalty for Osama bin Laden or Charles Manson or even Timothy McVeigh. That's my personal sense of morality. The state should not do that which the state condemns others for doing. If citizens can't murder people, we shouldn't do it either. We shouldn't premeditatedly and deliberately kill people. That's my sense, but that's my sense of morality, and so I would never participate in the death penalty as a prosecutor. But I think that you've just got to constantly ask yourself what is right. And I would say, Aisha, that you should never just rely solely on your own subjective sense of what's right and wrong. You need to get some objective input into what's right and wrong. And that means you want to read the law. You want to read texts regarding morality and justice. You want to get a mentor and you want to bounce it off of them. And you want to have people who have nothing to do with what you do and call them up and be able to say, hey, I got a situation. Maybe you can't even talk about the specifics of it, but maybe you can talk in broad generalities about it. But it is important that there's one group of lawyers, prosecutors, who think about what is right and not how to just get reelected, not what's going to get me in the paper, not what's going to get me an advancement, not what's going to help me be the governor, but what's right, whether it hurts you or not, whether it advances your career or hurts your career. We need a group of people who only reflect on that.
Thank you.
That was an amazing response. I think I always think about the tension point and relationship between morality, justice, and the law, and the ways in which attorneys, law students, professors, just like the conversation surrounding those topics is very, very interesting. So I appreciate your response to that. My next question is, and this is centered around some of the stuff that you talked about earlier with your presentation to the law students about jury and the power of jurors and your perspective on it. But what are the extensive measures used to uphold the standards of jury selection process in a case such as the George Floyd murder? And then what particular amendments do you feel need to be addressed with the Uniform Crime Reporting to improve its role for criminal justice?
This is a great question. So I am a person who believes in the jury system. I will freely admit sometimes it doesn't go right. I mean, you're getting a random group of 12 people and you never know what's going to happen. But I believe that over time, that random sampling does approximate community standards, and those standards are the sensibilities and the values of the people of that community. And they cannot be ignored. You have to pay attention to them. I think people who have extreme views on one side or the other, obviously, are going to be eliminated on for-cause challenges. I think it's important to have the peremptories where you just can go with your gut. I also think that we have to take a new look at Batson. And I think that we kind of look at Batson in terms of the defense stopping the prosecution Hey, is your screen jumping around or is that just mine?
Yours is staying right in the center of my screen, so I think you're good.
Okay, yeah, something where it's going. So anyway, but I think that prosecutors should make challenges of the defense on Batson as well. And I think that we've got to change Batson a little bit because a lot of judges say, oh, by the way, does everybody know what Batson is? Should I explain Batson?
Maybe just like a little bit of a clarification and.
Okay,
yeah.
so Batson versus Kentucky is a case in which, prosecutors were just kicking all the black jurors off the jury. Just all the black people out the door, bye. And, that practice was challenged and the Supreme Court said, look, people have a right to be on a jury. You can't just kick them off because they're black or brown or Latino or whatever, or white or whatever. You can't make a race-based challenge. You have to give a race-neutral explanation. Now, there have been a lot of cases where the judge says, I believe that you are making a pretextual preemptory challenge that is based on race, but you've been clever enough to give a race-neutral explanation. Therefore, I don't have any choice and you get to stay on the jury. I think those judges are making a mistake. I think if you suspect that juror is being kicked off for bias motivation, you should toss them. If you think that the motivation is partially biased, I think you should toss them. I think that as a judge, you should make sure that jury only has impartial people on it. I think that as a prosecutor, there are cases where you think that the racial composition of the jury would be better if it was, so usually the challenges are made by the defense and challenge made against the prosecution. I think the prosecution who has a duty to be a minister of justice and to do what's right should also make those for the purpose of making sure that the jury is representative and fair and impartial. I think that judges should take a little bit more license to make sure that the jury is a fair representation of the community. And let me just tell you, there was a recent Supreme Court case involving a guy named Curtis Flowers. Did you guys ever heard of this case? This is a case in Mississippi where they put this poor man on trial 6 separate times. And every single time they kicked all the black folks off the jury. And he ended up getting his case overturned at the Supreme Court. He was looking at the death penalty. And then they recently just let the case go because there was really never any evidence against this guy. But I would say we need to make sure I would ask the folks who administer the jury pool to always be looking for ways to make it more representative. Make sure that tribal licenses are in there, tribal, IDs are in there. Make sure that it's not just driver's licenses that you use, but state IDs, and go out of your way to make sure that the jury represents the community, because it should be more than just a box check thing. It should be something that we're truly endeavoring to do.
All right, General, thank you so much. So shifting from, we talked about a little bit of prosecutorial discretion. We talked about a jury and reform in that case. So I'm gonna shift it to police reform. I think this is very interesting to me, considering my youngest son is in the police academy as we speak in another
Congratulations.
state.
Congratulations. in Minnesota or Maine?
Actually in the state of Virginia.
Oh, Virginia.
The Commonwealth of Virginia.
Yeah, it's a Commonwealth, right?
Yes.
That's great.
So it seems that police, their unions, and the departments throughout the country have become more and more insular. And as more pressure for reform has been adding, anecdotally, it seems like those groups have dug their heels in more and more. How can people seeking reform and the policing community hear each other rather than speak past each other?
That is the question of the moment, and I wish I had an answer for it. I think we just have got to continue to keep trying to talk. And I would urge people who are concerned about excessive force and police misconduct to never forget that we really are dealing with an 80-20 problem. 20% of the officers generate 80% of the complaints. Most officers are not out there using excessive force and doing things that are wrong. And one of the problems is that for the small minority of officers that do things chronically bad, the problem is that they're not being eliminated, right? I think they need to be eliminated much more aggressively than they are. And if you look at, so for example, the city of Minneapolis, studies have come out fairly recently that there are officers that have more than 16 complaints that never been eliminated from the force. Derek Chauvin himself had 17 complaints, and he only had one sustained in 2007. But one of the cases that he was indicted for was not George Floyd, but a kid named John Pope. And John Pope was 14 years old when Derek Chauvin beat him up and put his knee on his neck and held him down there for 17 minutes. So even the case that a federal grand jury thought that's a crime, but the department didn't think so. I mean, if you look at in Washington, D.C., if you guys ever listen to the podcast called Reveal with Al Letson, there's a recent story about how these data folks got a hold of a bunch of data from the Metropolitan Police Department, which is the D.C. Police Department, and they found all these cases where officers were literally committing criminal acts, sexual assault, soliciting of sex workers, all kinds of serious crimes. And even when the disciplinary unit recommended discharge, they wouldn't do it. And so all these are like out of 46 cases where there was a recommended discipline, only 21 got any discipline and only 5 were discharged. And these are cases where you had officers that were literally pulling firearms on sex workers and stuff like that. I'm not making this stuff up. You can check it out yourself. Like, how do you expect an officer who's there, like your son, to do good, to help people, to assist people at their worst moment, which is what police do? But you're gonna make them work alongside somebody who said, I'm gonna pay for sex, but if you don't give it to me, I'm gonna pull a gun on you, which is what happened in this particular case. I mean, I'm telling you, there was this officer named Holtzclaw in Oklahoma City who was serially raping women who were sex workers and addicted to drugs. And he would just go to their homes, say, come out, do a sex act on me, and then leave. The only way these women complained about him, but the only way the department caught him is that they would look at his GPS and say, well, why did you go here? Why did you go here? Why did you go here? And what are you doing in all these places? He had no explanation. And then the dam just kind of broke. But it took a long time before real accountability came to that guy. I'm telling you that you can make police departments better by getting rid of bad cops, because it makes it easier and better for good cops, people who really want to be there to help their colleagues. Let me tell you one quick story. And I know I'm going on too long. I'm going to try to stop that. But I want to tell you about Carrielle Horn. Has anybody ever heard of Carrielle Horn? Any of y'all heard of Carrielle? Carrielle Horn was a Buffalo police officer. And Carrielle Horn was making an arrest on somebody who committed a crime or was suspected of one. And she was there with her partner who was also doing the same thing. She arrests her person and puts them in the squad, comes back and sees that her fellow officer is banging and beating on this man, on the suspect. She intervenes to stop it. He punches her in the face. Now you would think, okay, well, this guy's going to be in a lot of trouble and Carrielle's going to get, praised for intervening as she is supposed to. You'd be wrong. She was fired and lost her pension, and she had to sue to regain it. By the way, the officer who did that to that suspect was subsequently charged and convicted for a completely separate crime that had nothing to do with Carrielle Horn and went to prison for it. But then when he got out, he got a lawyer and somehow sued her for defamation for criticizing him. And then she didn't know about that. And he got a default judgment against her. And he's trying to collect her 60 grand from her right this very moment. So we've got to create an environment where officers who want to serve are supported. That's what we need to do. We need to prosecute criminal conduct. We need to fire people for improper conduct, and we need to embrace the officers who are there to protect and serve.
All right, Attorney General Ellison, we unfortunately are getting close to the end of our time. So I would like to pose one last question to you.
I'll try to make it quick.
Okay. Well, we really enjoyed it, so I don't want to rush you, but
Okay.
unfortunately, time keeps going on. So my question is, what role does protest play in American democracy?
Protest is fundamental to American democracy. Remember, you know, you got in your First Amendment, you have the right to freedom of faith, right? Congress shall make no law establishing a religion or abridging the free exercise thereof. You got the right to redress grievances, petition your government. You have freedom of the press, and you have the right to freedom of assembly. These are 1, 2, 3, 4, 5 rights that you have. And if you don't use them, that's bad on you. Protest is essential in American democracy. You must do it. It is the right thing to do. You have the right to do it. Now, I must say, burning stuff, breaking windows, and looting is a crime that I believe you should be prosecuted for if you do it, even in the context of a protest. And I will say, and so I just got to say that, but I will also say that protest is fundamental, redressing grievances is fundamental. And I also want to just tell you that sometimes breaking the law, if you do it peacefully and nonviolently, is also something you must do. Thoreau did it. Martin Luther King was arrested over 30 times. Over 30 times. Never hurt anybody, but he was arrested 30 times. And so I would say that protest in this case, if it had not been for protest, I don't think the governor would have ever appointed me to the Chauvin case. So there you go.
That is a wonderful point to wrap up. And Attorney General Ellison, I want to thank you, students, Sarah, Ambrose, Aisha. I am so proud of you. I am just absolutely, I could not be more proud of the University of Maine School of Law. And Attorney General Ellison, you have given us your entire day from morning through this lovely snowy evening. We are so grateful for your time. And we thank you for leaving us with many things to think about, because that's what we're going to do at Maine Law. And then we are going to find ways to take action. And with that, thank you all so much for being with us this evening. Everybody stay safe. Have a wonderful spring. And General, I hope your travels are safe as you leave us here in Maine. Good night, everyone.
Thank you. Good night, everybody.